Hi, my name is Nick Mermiges, and I'm a South Carolina attorney. And today I'm going to explain the grounds for divorce in the state of South Carolina. The most common ground that you'll find in South Carolina is the no-fault divorce. In order to get a no-fault divorce in South Carolina, you and your spouse have to have lived separate and apart continuously for 1 full year. And separate and apart means not in the same house. So even if y'all are in separate bedrooms, that doesn't count as separate and apart. You have to be out of the house for 1 full year. And once that's happened, you're entitled to bring an action for divorce and have the marriage dissolved without a finding of fault, without a finding that one party or the other is responsible. To get that 1 year clock started, there's nothing you need to file. You don't have to go to court. You just have to move out. Okay, and then once you've been out for more than a year, you can go to a lawyer and bring an action on those grounds. So that's the no-fault divorce. Now, even though you don't have to file anything, one thing a lot of folks wind up doing is bringing an action for separate support and maintenance during that year. Because when people are married, a lot of times their finances will be real intermingled, or they'll own a home, or there will be kids, or one spouse will be the spouse that really pays for everything. So if there's some uncertainty there, a lot of folks like to bring an action for separate support and maintenance, and that can get them things like alimony, obviously child support, although DSS will get you child support for free if you're living separate from your spouse. You should know that. The right to stay in the house and not be bothered by the other spouse, and also if they're kids, a temporary custody arrangement. So all that stuff can be addressed more or less immediately as soon as one party moves out of the house. So there is an action to bring, and a lot of folks, it does make sense to do that. And of course you can work out the final agreement, who gets what, who's got to take care of the debts, who gets the house, what happens to the house, whatever other investments there are, how those are split up, retirement and so forth, alimony. You can work that all out really at any time and come to a final settlement agreement. So by the time that year passes, there's not anything left to litigate, is what lawyers would say. Nothing left to fight about in court. So a lot of people do like to file sooner, but it's not required. There's nothing you need to do to start that clock ticking. Apart from that no-fault ground, there are several fault-based grounds. One that's become obsolete, so I'm not going to talk about much, is abandonment. That means the other spouse has been gone for more than a year. Sounds a lot like separation for more than a year. It's very rare to see anyone bring an action on the grounds of abandonment, unless you're really trying to show, that he ran off to Vegas and left me and the kids, because that would influence how the court splits up the marital estate. Otherwise, people don't use that. There's really no grounds, or there's no frequent use of abandonment as a fault-based ground. The most commonly used fault-based ground is adultery. And why is that? Well, because adultery really does break up a lot of marriages, and folks want to get out, and they also need the acknowledgement that that's what's happened. And so adultery can be grounds for fault-based divorce. You don't have to wait the year when there's an adultery assertion. Now, the issue is proving adultery. Okay, you don't have to show the adultery happening, but you do need to show what's known as opportunity and inclination. Okay, inclination means that your spouse is out there looking, trying to cheat. An opportunity would be they have the physical chance to do so. The easiest or most common way to prove that is going to be through the use of a private investigator. So photographs of your spouse going into someone else's house or going into a hotel room with someone. Sometimes also there will be an admission between the spouses, particularly that's most useful if it's in writing, so in the form of a text message or an email saying, yes, I admit that I cheated. One thing to look out for is that a defense to adultery is condonation. So if you let the spouse back, and you let 2 years pass, try to work it out, and then want a divorce on adultery, if your spouse wants to fight you, they're going to have a defense, and you're going to have to be separate and apart for that full year. So that's something to think about. But in general, the benefit to bringing an adultery-based action is not having to wait that year. And also, depending on the circumstances, the court is going to consider who's at fault for the breakup of the marriage when it splits up the marital estate. Okay, so it's something that might influence how the assets and debts are divided. And obviously, it's bad for the person that is responsible for the marriage falling apart. The next ground is physical cruelty, and that sounds just like it is. Now, proving that, things like police reports, photographs, records of conviction, witnesses. That's how you would establish that one spouse's physical cruelty has been the cause of the breakdown of the marriage. And if you're actually dealing with a physical cruelty separation, you're really very likely going to want your lawyer to seek an order of protection from that abusive spouse as well, or at the very least to file a motion for temporary relief, where they ask the family court to enter a no contact order. Okay, and that way, if the spouse comes around in violation of that no contact order, they can be held in contempt of court and potentially jailed for contempt of court. Apart from adultery and physical cruelty and abandonment, the final fault-based ground would be habitual intoxication. The intoxication doesn't have to be liquor. It can be narcotics or other drugs. And you really have to demonstrate that the intoxication was the cause of the breakdown of the marriage. So, again, police reports, or if someone lost a job because of the intoxication, employment records, and your lawyer can help you subpoena this stuff, showing basically that someone was terminated, and then them being terminated made it so that the marriage couldn't work out. Besides that, witness testimony and medical records. So that's how you prove that kind of stuff. And in general, all those fault-based grounds, the reason you would be inclined to go that route would be one, that you kind of need the catharsis of having a judge acknowledge that this is what happened to you, a declaration that they find that what you're saying is the truth. Two is not having to wait that full year to get the actual divorce and move on with your life. Three is that when fault becomes central, the court's going to consider that fault when it splits up the finances. Now, the downsides are, of course, that sometimes it requires more lawyer time to prove those things. Having a lawyer issue subpoenas takes lawyer time, and developing that record evidence takes lawyer time. And so you may not want to spend all that extra money on a lawyer because there's no guarantee when you bring an action that your spouse, the other side, is going to have to pay for your attorney's fees. That's not something that happens every time. Really kind of depends on financial need. So there's a lot of things to consider, but those are the grounds that are available to you if you want to bring a divorce in South Carolina. So I hope that this was informational or helpful in making your decision, and I wish you all the best. Thank you for listening.